Thank you very much, Presiding Officer. First of all, I am delighted to be speaking in this Stage 1 debate on behalf of the Delegated Powers and Law Reform Committee. As has already been touched upon by others, the bill includes very significant powers which can be exercised using the maid affirmative procedure. And given the maid affirmative procedure was until recently relatively unusual, I want to take a few moments just to highlight the committee's recent inquiry on its use during the pandemic. This work actually helped inform and shape the committee's findings for the coronavirus bill in front of us now. The maid affirmative procedure, which allows the Scottish Government to change aspects of the law straight away, was usually only seen by the Parliament once or twice a year. Yet since March 2020, the procedure was used more than 150 times. In scrutinising these changes to the law, the committee understood that it was necessary to use emergency powers to respond to the public health emergency. However, our inquiry raised concerns around how clear and accessible the laws created with these powers actually were, particularly when they came into law prior to being scrutinised here in the Scottish Parliament. So I highlighted in our inquiry report a set of principles that might provide the basis for parliamentary scrutiny where legislation includes such provisions, and that this bill is a prime example of that. Our Stage 1 report, reflecting what we found in our inquiry, recommended that the Scottish Government bring forward amendments for each power which can be exercised subject to the maid affirmative procedure. And these statutory requirements would be threefold. Firstly, that each SSI is accompanied by a written statement explaining and providing evidence for why the regulations need to be made urgently. Secondly, that the Government include an assessment of the impact of the instrument on all those likely to be affected. And thirdly, that such SSIs are subject to a sunset provision so that the changes to the law don't continue to be in force indefinitely. From the response to our Stage 1 report and also the comments from the Deputy First Minister earlier, the Scottish Government is intending to bring forward an amendment to provide an explanation of urgency and also considering adding a sunset provision to the powers at Stage 2, and I am sure that colleagues in the committee will welcome those. Turning briefly to each of the 5 powers which can be exercised subject to the maid affirmative procedure, there wasn't the same consensus among committee members. And these are the 5 points: the public health protection regulations in Section 1, the continuing operation of educational establishments in Section 8, school boarding accommodation in Section 9, the student accommodation in Section 10, and the early release from prison or a young offenders institution in paragraph 24(1) of the schedule. Now, some members of the committee considered that the Scottish Government did not make a sufficient case for why these powers should be delegated, and such changes to the law could instead be brought forward quickly under primary legislation. However, the majority of the committee, that's 3 of the 5 members, were content with the delegation of each of the powers in principle. Nevertheless, on school boarding and student accommodation, the committee considered by a majority of 3 to 5 members that each power should only be capable of being exercised subject to the affirmative procedure. I also note that the COVID-19 Recovery Committee's recommendations around the Henry VIII powers, our call for a statement of urgency when making such regulations in an emergency might provide additional limitations to the potential use of the maid affirmative procedure when exercising such Henry VIII powers. Now, very briefly, Presiding Officer, the committee also is working with the Scottish Government to develop a protocol for what we have called an expedited affirmative procedure, and the Deputy First Minister touched upon that earlier on today. Now, this is work that certainly kind of follows on from previous protocols that have been established between the Delegated Powers Law Reform Committee and also the Scottish Government in the past. I certainly believe that this particular protocol could be used in place of the maid affirmative procedure. So, in closing, I will restate the committee's consistent and strongly held position that the Scottish Government should use the affirmative procedure in all but exceptional and urgent circumstances. And I note that what the Cabinet Secretary said earlier in the debate, and the committee does look forward to seeing the fruits of that when we next consider the bill following amendments at Stage 2. Thank you.